Hi everyone. So today's unit that we'll be doing is Principles of Contract Law, and my name is Shazia Khan. The learning outcome we'll be doing is learning outcome 4 today, which will be looking at understanding how a contract may be breached. But before we go into learning outcome 4, I want to just give you a recap of the last session, which was learning outcome 3. So in learning outcome 3, we looked at understanding the principal factors that vitiate a contract. We looked at elements of what vitiating a contract is, understanding the principal factors. We looked at elements that vitiate contract, things like mistake, misrepresentation, duress, undue influence, and illegality. We looked at the effect of them on a contract as well. We looked at the different types of mistakes. So you get common mistake, mutual mistake, and unilateral mistake. And we looked at them with reference to cases such as, for common mistake, we looked at Bell and Lever Brothers, 1932. We also looked at mutual mistake with the reference to the case of Raffles and Wiltshire, 1864, and unilateral mistake. We looked at the case of Hartog and Colin Shields, 1939. We also looked at elements of misrepresentation and the different types of misrepresentation, which things like fraudulent misrepresentation, with the reference to the case, famous case of Derry and Peake, 1889, negligent misrepresentation with reference to the case of Headley, Bryan and Heller, 1964, and innocent misrepresentation. We also looked at elements of duress. So we've got physical duress and economic duress. We looked at undue influence, and we looked at actual undue influence, which is direct manipulation, and presumed undue influence with reference to cases such as Lloyds Bank and Bundy, 1975. We also looked at the element of illegality within a contract and how that voids a contract, such as contracts for criminal activities, etc. We went on to look at outlining various types of contractual mistakes, so common mistake, mutual mistake, unilateral mistake, with reference to its effects on a contract, but also with reference to case law as well. We looked at the capacity to enter into contractual relations, so certain groups we looked at. Firstly, we looked at minors' contractual capacity with reference to voidable contracts, contracts for necessaries, and beneficial contracts of service. We also looked at the mental incapacity and intoxication in regards to making a contract void. We looked at elements of different types of misrepresentation and mistake. So we looked at fraudulent misrepresentation, negligent misrepresentation, innocent misrepresentation, and we looked at cases with reference to that, the consequences of that within the Misrepresentation Act 1967. We looked at types of mistake as well, common, mutual, and unilateral, and the remedies available. So things like recession, damages, and for mistake, void contract, rescission, and equitable remedies. We looked at how a contract can be discharged as well. So we looked at things like discharge by performance, and the key points for that with reference to cases like Cutter and Powell, 1795. And we also looked at discharge by agreement and looked at the different types of discharge, mutual discharge and release with consideration. We also looked at elements of discharge by frustration and looked at the key requirements and the key cases, a really old case of Taylor and Caldwell, 1863, and we looked at limitations and examples of frustration. We looked at discharge by breach with the key types, actual, anticipatory with reference to cases, and the effects as well with reference to breach by condition, breach of warranty, and breach of inanimate terms. We then went on to look at how lack of capacity, illegality, and public policy may void a contract. And we looked at lack of capacity, and we looked at key groups, minors, mental incapacity, and intoxicated people. We looked at illegality and examples of that, contracts to commit a crime or fraud contrary to statutory provisions, and contracts defeating revenue. We also looked at public policy, contracts restraining trade, immoral contracts, and contracts interfering with justice, and contracts opposed to public welfare. And all these we looked with reference to cases as well. We looked at remedies and outcomes as well. We looked at how undue influence and duress may void a contract. And we looked at undue influence in family and professional relations as well, and how that would void a contract, the effect on contracts. And we also looked at elements of the nature, examples and key cases, and the effect on a contract for duress and undue influence, and how it would affect a contract in regards to the comparison between duress and undue influence, and how that would impact on a contract, and the effect it would have on a contract, whether the contract would be void or not void, and the also what the aggrieved party can do if the contract is void. So that was learning outcome 3. So now we're moving on to learning outcome 4, which is to look at understanding how a contract may be breached. So the indicative content for today's session is to look at breach of contract by one or more parties, looking at anticipatory breach and repudiated breach, the effect of breach of contract on the remaining contractual duties, liquidated damage clauses and penalty clauses. We'll also look at liquidated damages clauses and penalty clauses, how damages can be calculated, equitable remedies, and also requirements for accessing equitable remedies. So key terminology. So what is a breach of contract? In UK law, is where one party fails to perform their obligations under a contract. So business, maybe a business or services or goods. Remedies are available for breach of contract, which would be things like specific performance, rescission, etc., which we'll go through in more detail. So there's a video there on the next slide, and that you could watch in your own time, and that looks at elements of breach of contract and remedies as well. And it's quite a detailed video that you could look at and watch in your own time. Thank you. Understand how a contract may be breached. So in the UK, a contract is breached when one party fails to fulfill their agreed obligations without a valid reason, which can include not performing actions outlined in the contract, not meeting deadlines, or delivering substandard goods or services, potentially leading to legal action and the element of the contract being breached. The next one is types of breach. So you've got actual breach and you've got anticipatory breach as well. So actual breach is failure to perform obligations at the time of performance is due. The effect is allows the innocent party to claim damages. And then anticipatory breach is when one party indicates before performance is due that they will not fulfill the contract. And cases such as Hoster and DiL-Unit-Principles 1853. So actual breach, which we looked at a little bit, just to identify, an actual breach occurs when one party to a contract, as we mentioned, fails to fulfill their agreed upon obligations within the specified time frame, essentially not performing their part of the deal when it is due, which allows the other party to seek remedies for breach. It means that the breach has already happened, unlike an anticipatory breach where a party indicates they will not fulfill the contract. So an example, or some examples of actual breach, is a direct failure to perform a contractual obligation at designated time, and that was the element in Poussard and Spears case, 1876. Or another, a contractor failing to deliver a completed project by agreed deadline. The consequence is that the non-breaching party can pursue legal remedies such as suing for damages, terminating the contract, or seeking specific performance in that case. Then you've got anticipatory breach, and this occurs when we mentioned earlier, when one party to the contract indicates they will not fulfill their obligations before the agreed upon deadline. And this was quite popular in the case of Hochstead DiL-Unit-Principles case, 1853. So a breach of term is where one party fails to fulfill their obligations under an agreement. This could be include breaking a written or verbal term or an implied term. And These elements are in regards to condition, they break the condition, warranty, or an innominate term, which the diagram shows you there with reference to the definition, the effect of the breach on a contract, and the key case in reference to that. Remedies available to the innocent party. So you've got damages, which are consequential, compensatory, consequential, nominal, and punitive. And key case for that is Hadley and Baxendale, 1854. So if a contract is breached, where contract party fails to fulfill the obligation as agreed, when a breach of contract occurs, the non-breaching party may pursue different types of remedies depending on such a severity of the case. So if another party breaches your contract, you may be frustrated and want to take, litigation against them. So, you would have, remedies available for you in that instance, when the contract is breached. We're going to go through them now. So the first one is specific performance. Specific performance is a court order which requires a party to fulfill their contractual obligations. It's a remedy that can be used when monetary damages are not enough to compensate the party. So this is where, where one party does not perform the contract. And it's a remedy by the court whereby the court will issue an order requiring the party to perform a specific act, such as complete performance of the contract. And if they don't, then obviously they would be awarded remedies. And an example of specific performance is a venue that contracted with a popular comedian to perform on a specific evening. When a comedian attempted to pull out of the contract, the venue appealed to the court for specific performance in that instance. The next one is an injunction. An injunction is a court order that can require or prohibit a person from doing something. So in contract law, injunctions can be used to protect businesses or prevent a breach of contract. So you could have different types of injunctions, prohibitory injunctions, mandatory injunctions, and it is where the court would prohibit a person from taking a particular action. So it's up to the court to perform this, and it would be the court preventing someone from doing something. Rescission. And this is a contract, is a legal remedy that allows a party to cancel a contract and return to their pre-contractual state. It's known as unwinding a transaction, and contract can be rescinded if there's misrepresentation, if there's mistake, duress, any sort of undue influence, any fraud or lack of capacity. So that's when a rescission will play a big part in it. The next one is quantum merit, and this is a legal term that refers to a claim for a reasonable amount of money for services or goods provided. It's a common law method for assessing damages. An example of a quantum merit would be if a plumber fixed a leaky pipe and did not have a prior agreement with the property owner on how much that they would pay for the services. The plumber would still be entitled to be paid for them services. Key consideration of breach of contract. The process begins when identifying the essential elements constituting the breach. These elements include the existence of a valid contract, unequivocal breach of contractual terms and resultant damages. So these have to be elements that have to be considered. So it could be causation and remoteness, as in the case of Hadley and Baxendale, 1854. Mitigation of loss, so the innocent party must take reasonable steps to minimise their loss. And liquidated damages, predetermined damages agreed upon in the contract enforceable if reasonable. And these are the requirements, providing that key elements are met and you make sure that there's an existence of a contract, that and the contract has been breached and that you have suffered, these are sufficient enough to amount for consideration in breach of a contract. So the summary table here looks at the types of breach of terms, damages, specific performance, injunction, rescission, and quantum merit. We're looking at the description of each one, what they do, and key case examples to identify that, and key laws to identify how this breach would occur and what remedies are available. So you can have a look at that in your own time. Breach of contract where the actual anticipatory undermines the agreement's terms and allows the party to seek some sort of remedy. So that they're the court there to help the individual party seek some form of remedy. Whether it's a condition, warranty, or inanimate term, it determines the breach and remedies are available. So courts have the right to protect the rights of an innocent party while ensuring fairness and adherence to contractual obligations. So, you know, the court is there to protect individual rights and make sure that each individual has, you know, performed their duty as they should. The effect on breach of a contract. So when a contract is breached, the affected party can potentially, as we mentioned, seek remedies, including financial compensation to cover their losses, the ability to terminate the contract, or in certain situations, a court order requiring the breaching party to fulfill their contractual obligations, depending on the severity of the breach and the specific terms of the contract. Essentially, a breach can significantly impact the legal enforcement of the contract and potentially result in legal action against the breaching party. So the types of breach we've got here. You've got actual breach, which occurs when one party fails to fulfill their obligations by deadline or during performance. And the effect on contract is the innocent party can terminate if breach involves a condition or claim damages. Key case in regards to that, as we mentioned earlier as well, the key case is Poussard and Spears and Pond, 1876. Anticipatory breach, this occurs when a party indicates that they will not fulfill their obligations before the contract is due. For example, an employer might say they can't meet a deadline, and this is the effect on contract. The innocent party can terminate immediately or wait until performance is due to claim. The case of Hoster against DiL-Unit-Principles, 1853, and repudiated breach is where a serious breach that undermines the entire contract or deprives the innocent party, and then the effect on contract can terminate the contract. And the case is Hong Kong Fire Shipping and Kowalski. So breach of contract by one or more party. So when considering a breach of contract occurs when one party fails to fulfill its obligation as outlined in the contract. This could be something relatively minor, such as a couple of days late, or something more serious. A law contract is legally binding agreement between two or more parties with the capacity to agree. For a contract to be valid, it must have four essentials, as we mentioned: offer, acceptance, and the consideration and intention to create legal relations. So here, a breach of contract occurs. In actual breach would be the Poussard case, and the effect of the breach involves a condition, and the innocent party can terminate the contract or claim damages. The anticipatory breach. As we mentioned, anticipatory breach occurs when one party, occurs when one party's intention to fulfill its contractual obligations to another is breached, and they don't fulfill these obligations, and they don't meet the deadlines, and the damages can be claimed by the other party. They can claim expectation damages or consequential damages, or reliance on damages. And an example would be a software company informs a client they won't be able to complete a custom software application by the deadline. So this is an example of anticipatory breach. The next one is repudiatory breach. A repudiatory breach is a breach which is so serious that it potentially deprives the other party of full benefit of the contract. So after a repudiatory breach, the other party can decide to terminate the contract or not. In all contracts, some of the terms and condition clauses will be more important than others. The terms of a contract may expressly state that a breach of specified type is a repudiatory, giving the other party the right but not the obligation to terminate the contract. Before terminating a contract, it's essential to be confident that you have the right to repudiate. If a breach is not expressly stated to be repudiatory in the contract, it is risky to terminate the contract. If you terminate, you would be relying on common law right to terminate for repudiatory breach, and in the event of dispute, a court will decide the repudiation was lawful. There are no major implications of repudiating a contract or deciding not to do so. There are choices to be made which impact the damages that are recoverable. Many businesses have detailed written contracts negotiated with the other party, or which may be your own terms and conditions, or those supplied by supplier or customer. Whichever is the case, if a written agreement is in place, it's essential to be careful. A contract will commonly expressly state what breaches give rights to terminate and may also include procedures to comply with where there has been a repudiated breach if the aggrieved party wants to then terminate. Failure to comply with the process can sometimes render what would otherwise be lawful termination of a contract unlawful, even if there's a clear contractual right to terminate. So you've got to be really careful when it comes to repudiating a contract. The effects of breaching contractual duties. So a breach of contract occurs when one party, as we mentioned earlier, of the parties fails to perform the bounded terms and conditions of the contract. The other party can sue the party that caused the breach for money in such cases. Sometimes they can approach the court and ask the court to force the other party to perform as promised. The overarching goal of it is to place the harmed party in the same economic position they would have been in no breach of contract occurred. As a result, default remedy available for breach of contract is monetary damages. So if the breach involves a condition, or if the breach involves a warranty, or if the breach is anticipatory, or if the breach is repudiatory, they are the effects of breach on remaining contractual duties that need to be taken into account. So, they've got effect of condition, warranty, and anticipatory or repudiatory. So this summary table identifies the aspect which is, and the description, key cases and effect on remaining duties. So for actual breach, failure to perform obligations when due, cases again, Poussard and Spears, the effect on remaining duties, the innocent party can terminate condition or claim damages. The anticipatory breach is declaration or indication of non-performance before the due date. Case Hoster and De La Torre, and the effect on remaining parties, innocent party can terminate, immediate or wait with the claim for the damages. Repudiatory contract is serious breach depriving the innocent party of the main benefit of the contract. The case is Hong Kong via shipping, Kawasaki, and the effect is innocent party is discharged from obligations and may claim damages. For breach of contract, breach of fundamental term, going to the root of the contract, case is Poussard and Spears. Discharge is innocent party's obligation, and breach of warranty is breach of a minor term, and the case of Bettany and Guy, 1876, the innocent party must perform but may claim damages. So in conclusion to that, the effect of breach on contractual depends whether the breach is actual, anticipatory or repudiatory, and involves a condition, warranty or inanimate terms. and the courts aim to balance fairness by discharging obligations where justified. So they need to make sure that they're looking at the severity of the case, where there's been any sort of breach of damages or any sort of breach that occurred to make the contract void. They must take all these things into account, whether the breach is anticipatory, repudiatory, or actual, and whether it involves a condition, warranty, or non term to make their decision. So the role, 4.2, the role of equitable remedies in contractual breach. So equitable remedies play a crucial role in contractual breach by providing an alternative solution beyond mere monetary compensation to ensure fairness, allowing courts to address situations where damages alone would not achieve justice, often by compelling a party to fulfill their contractual obligations through measures like specific performance, injunctions, depending on the unique circumstances of the breach. Unlike common law damages, which aim to compensate for losses, equitable remedies can actively enforce the terms of a contract by specific actions from the breaching party. So these need to be taken into account. So the types, the next slide is types of equitable remedies. We've got types of equitable remedies available. The first one is rectification, and then which is correcting written contracts to reflect the true intention of the parties in the summary table. The purpose, ensure the contract accurately represents the agreed terms, as in the case of Craddock Brothers and Hunt, 1923, specific performance, court compelling a party to perform their contractual obligations, ensuring fulfillment obligations when damages are inadequate, the case of Beswick and Beswick, 1968, an injunction, which we went through a little bit earlier as well, a court ordering preventing a party from breaching or continuing to breach the contract, restrains harm or unauthorized actions, Warner Brothers and Nelson, 1937. So we'll go into more detail about rectification, so you've got a little bit of an idea what rectification is and how it plays a big part when it comes to elements of breaches of a contract. So rectification is an equitable remedy that allows a court to fix mistakes in written documents, such as contracts, to accurately reflect the parties' intentions. It's only available for written documents, not oral documents. It is available only in relation, as we've said, to written documents. Oral documents cannot be rectified under this. This is obviously where the courts will rewrite the terms of a written agreement in order to correct a mistake and restore parties to their original bargain. So, you know, they would look at rectification here and why it needs why there's a need for it, and also, you know, make sure that the contract is, if there's any sort of mistakes made, that it's gone back to the old one. Also, the case in regards to rectification is the case of Craddock Brothers and Hunt, 1923. Also, if parties agree to rectification, they may correct the mistake by entering into a deed of rectification. It is necessary to apply to the court for an order for rectification if either there's a dispute or the parties wish to ensure the rectification has retrospective effect. The burden of proof is on the party seeking rectification, who must be able to produce convincing proof that the agreement does not reflect the intentions of the parties, and the agreement as rectified will reflect those intentions then. So the burden of proof is on the party. The next one is specific performance. And we've gone through these briefly, but it gives you a little bit of an outline of them in more detail. So specific performance is a type of equitable relief available in contract law disputes in England and Wales. Unlike the more common remedy of monetary damages, specific performance orders the breaching party to perform their obligations under the contract rather than merely compensating the injured party with money. This type of remedy is typically sought in cases where monetary compensation is not seen as adequate remedy to address the harm caused by the breach of contract. And some examples include the sale of unique items such as artwork or real estate property, where the specific item or property cannot be simply purchased elsewhere. The aim of specific performance is a legal remedy to enforce the original terms of the contract by requiring the breaching party to specifically perform or deliver what was promised. Court orders for specific performance are only granted under certain circumstances. The legal basis for the remedy of specific performance is preliminary delivered from the Senior Courts Act 1981, which allows the courts to compel party to act or refrain from acting in a manner that fulfills their contractual obligations. The specific performance remedy has also developed under case law that outlines the principles of considerations guiding its application. The courts have consistently emphasized that specific performance is not an automatic right. It is granted at the discretion of the court based on the specific circumstances of each individual case. A court principle, a key principle in the application of specific performance is the requirement that the contract must be clear, it must be fair and capable of specific enforcement without causing undue hardship to either party. So this ensures that the remedy is applied in a manner that is just and equitable, reflecting the court's broader role in achieving fairness in contractual disputes. So, the courts have the authority and need to take into account that. The case in regards to, a popular case in regards to that is Bestwick and Bestwick 1968. In Bestwick and Bestwick, an uncle sold a business to his nephew with the agreement that the nephew would pay an annuity to the uncle's widow. After the uncle's death, the nephew failed to pay the annuity, and the court appealed held that specific performance could be ordered to enforce the agreement in this case. Another case is a case of Patel and Ali, 1984. In this case, a claim for specific performance was considered following a breach of contract in relation to a house sale. The seller of the house had become seriously ill and was no longer able to move out of the house. The court held that specific performance would not be granted because it would cause undue hardship to the defendant. This case is significant for illustrating the court's consideration of fairness and the personal circumstances of the parties when deciding whether to grant specific performance or not. Another case which is quite popular in regards to specific performance is the case of Rainbow Estates Limited and Token Hall Limited, 1998. And this case highlighted the limits of specific performance concerning contracts involving personal judgment or services. The court was reluctant to grant specific performance where it would require ongoing supervision or involve subjective assessments. The next one is injunctions. So an injunction is a court order prohibiting a person from taking a particular action, a prohibitory injunction, or requiring them to take a particular action, a mandatory injunction. A party who breaches an injunction can be held in contempt of court, which can result in a fine or imprisonment. Injunctions are often required to protect businesses. It is essential that the application is made promptly, not only to increase the likelihood of the judge being satisfied that the order is required, but also to deal with whatever threat the business is facing. The most common type of injunction is where employees leave and set up competition in breach of restrictive covenants in their contracts. An injunction in these circumstances can prevent them from operating for a period of time, or it may require them to deliver up confidential information that shouldn't have been taken from their former employer, as well as disclose details of people who they have contacted in preparation for their new business. Injunctions are also sought where intellectual property rights have been breached and protection is required. So, there are different elements of that in regards to injunctions, So you do have different types. You have prohibitory, as we mentioned, and mandatory. And the prohibitory one is the famous case of Warner Brothers and Nelson, 1937, where an actress was restrained from working for competitors after breaching her exclusive contract with Warner Brothers. So there are different elements of that. And, there are different examples. So if a company wants to build an overtop on an old gravesite, the owner of the land could file an injunction against that company to not build that. The landowner would be the plaintiff, and the company trying to build would be the defendant. And an injunction would be appropriate in this case because it prevents irreparable harm. So there are elements of that that would fall within an injunction and why there was a need for it. The breach in an injunction threatens irreparable harm, and the remedy is just and equitable in certain circumstances. Requirements for accessing equitable remedies. The influence of the equitable remedies are available for individuals to use, and are discretionary and include the clean hands doctrine. He who comes to equity comes with clean hands. So the parties have to be fair in this as well. They are, you've got to bear that in mind. The principles, equitable remedies are broad in scope, flexible, directed application, and supplement common law. Unlike common law remedies, equitable remedies are not constrained by concepts such as remoteness of damage or causation, thereby enabling equity to go beyond common law in redressing loss and damage available for people. So, they have to take that into account. And they have to look at no adequate legal remedy. So equitable remedies are granted where damages are inadequate to compensate for the breach. There's no undue hardship, so the remedy must not impose unreasonable hardship, and timeliness that they prompt to avoid any sort of perception of waiver. Comparison of equitable remedies. So we looked at rectification, specific performance, and injunction, and the purpose of each one in that diagram, applicable cases to it, and key limitations, and the applicable cases to that. So Craddock Brothers for rectification, Bestwick and Bestwick for specific performance, and Warner Brothers and Nelson for injunctions. So in conclusion, equitable remedies like rectification, specific performance, and injunctions play a vital role within addressing any sort of breaches of contract. Courts will grant these and be fair and just when granting them, and each equitable remedy is based on the fairness and also intended to protect both parties as well. So types of breach, including breach anticipatory, repudiatory breaches as well. So courts here, one or more parties have breached the contract. As we mentioned, the consequences depend on the severity of each case, and there are breaches, two types of breaches are anticipatory and repudiatory breach that are taken into consideration. So types of contract in this summary table is actual breach, which it defines it in this contract, the effect on contract, and the key cases. Anticipatory breach, which we've been through with reference to definition, effect on contract, and the key cases. Repudiatory breach and a series of breach, and the effect on contract and the key cases, and minor breaches, failure, the definition, effect, and key cases. So you can have a look at this summary table in your own time. We've been through it before a bit briefly. We'll go through it a little bit more in detail now. So anticipatory breach occurs where one party clearly does not intend to fulfill their contractual obligation. They may communicate their intention or may be obvious from their actions, for example, by failing to start work. While the contract has not yet breached, it can be anticipated that a breach will occur. So, there's anticipation that the breach will occur here. And the key features, it can be communicated explicitly or impliedly, and the innocent party can terminate the contract and claim damages. Key cases, as we mentioned earlier, Hoster and DiL-Unit-Principles, 1853. Then we've got repudiatory damage, a breach, which we went through a little bit earlier on as well. So a repudiated or fundamental breach is so serious that the injured party can choose to terminate the contract. An example might be if a builder stopped turning up so that no progress was being made on the agreed work. Damages may be payable along with the ending of the contract. The breach, to qualify for repudiatory, the breach must go to the root of the contract, be substantially inconsistent with the contract terms, deprive one party of the expected benefit, or to be unfair to the injured party to the extent that they could not be expected to continue with the contract. If the term breached is a condition of a vital term of a contract, the innocent party may be entitled to end the contract, even if the consequences of the breach are not substantial. This is the only breach of contract that releases both parties from their obligation. Other types of breach still require the innocent party to adhere to the contract terms, even if they are successful in obtaining damages. For example, if a builder's work required modification by a new contractor, the injured party might receive damages, but would still be liable to pay for the work. Actual breach. Is where one party fails to perform their obligations as required at the terms of at the required time. And then you've got the key features of it and the case again. Minor breach is where a minor involves the failure to perform a non-fundamental term, typically a warranty. Key features and the key case is better dear guide. Comparison table is there for you to have a look at on actual breach. Actual breach, anticipatory breach, repudiated breach, and minor partial breach. The effect on the innocent party's obligations. So this would depend on the effect on condition, warranty, anticipatory breach, or repudiatory breach. Conclusion, understanding the type of contract breaches, including actual, anticipatory, repudiate, and minor, is essential for determining the remedies available. Courts will assess the nature of the breach and ensure there's fairness for both parties with safeguarding any sort of contract purposes. So the courts would base everything around, each individual case and the severity of the cases. 4.4, the meaning of damages in relation to contracts. In the context of contracts, damages refers to monetary compensation awarded by a court to a party who has suffered a loss due to the breach of the contract, aiming to put the injured party back in the position they would have been if the contract had been fulfilled properly. Essentially, it's a financial remedy for a broken contract designed to compensate for the actual losses incurred by the non-breaching party. Types of damages. So you've got elements of that to go through. So the first one is compensatory damages, which is monetary compensation for actual losses suffered by the injured party. The purpose is to restore the injured party to their pre-breach position. And the case is Hadley and Baxendale, 1854. Consequential breaches, compensation for indirect foreseeable losses caused by the breach. The purpose is to address losses beyond the immediate contract, but foreseeable at the time of agreement. The case is Victoria Laundry and Newman Industries, 1945. 49. Nominal damages, small monetary awards when no actual loss has been suffered. The purpose is recognise the breach without significant loss. And the key cases is Stanforth and Lyle, 1830. Liquidated damages, which is pre-agreed compensation specified in the contract for breaches. The purpose is provide certainty and avoid disputes over the amount of damages. And the key cases is enforced if the clause reflects a genuine pre-estimate of losses. And punitive damages is rare in contract law, awarded to punish egregious behaviour, and the purpose is discourage malicious or reckless conduct. And the key case is typically unavailable in UK contract law. So the first one is we're going to look at is liquidated damages. which is a fixed amount of money that a party pays to another in the event of a breach of contract. The parties agree on the amount in advance, and the injured party can collect the liquidated damages without having to prove actual loss. And key case for that is Dunlop Pneumatic Tyre Co. and George and New Garage Motor 1915. The next one is penalty clauses, which is a clause imposing an amount payable upon breach that is excessive or punitive. Enforceability is not enforceable under UK law. And key cases Cavendish Square Holding BV and Talal Ek Magdisi 2015. So how damages are calculated? So damages a breach of contract happens when one party, as we said, does not fulfill the obligation of another party. And it's up to the court to award the damages. So it's what the expectation losses, compensation for the profit or benefit of the injured party. It might be the market value, so damages based on the contract price and the market price of the time of the damage. So an example, if a seller fails to deliver goods, damages would be difference between the contract price and the price of the goods elsewhere. Loss of enjoyment, so definition, compensation for non-economic losses such as disappointment or inconvenience. Case of Jarvis and Swan's Toes, 1973. Then we've got the summary table that looks at the different types of damages. So liquidated, penalty, expectation loss, market value, and loss of enjoyment with the definition, purposes, and cases that are used. So in conclusion, damages and in contract law serve to compensate the injured party for losses resulting from a breach, while liquidated clauses provide certainty. Penalty clauses are unenforceable unless they reflect legitimate interest, and courts would assess damages based on expectation loss, market value, or loss of enjoyment, considering factors such as foreseeability and mitigation. Remedies available for breach of contract. So when a contract is breached, there are remedies available to the party, and if the breach had not occurred. And remedies, so you've got legal remedies. You've got the first one is compensatory damages, and these are intended to compensate the injured party for loss or injury. These damages are called actual damages. Compensatory damages include two subtypes, general and special damages. General damages compensate you for direct losses you suffered due to a breach. For example, if your supplier failed to deliver goods on time, you might have needed to purchase replacement goods. These goods may have been more expensive because you have had to buy them at the last minute. The general damages that the supplier might owe you would include the difference between the more expensive goods price and the price you were going to pay to the supplier, as well as refund of any money prepaid to the supplier and reimbursement for expenses if you are to return unused goods to the supplier. The next one is consequential damages. And consequential damages are damages that are not a natural result of breach of contract, but are reasonably expected by both parties at the time of the contract. They're also known as special damages as well. An example could be delay in delivery machinery leads to lost profits in manufacturing. So if a supplier fails to deliver something, that's the case of Hadley and Baxendale, 1854. Then we've got nominal damages, and these are a small amount of money that a court orders someone to pay to another person who has been harmed, but not seriously. They are awarded when a judge or jury finds in favour of one party, but concludes that no real harm was done. Then we have liquidated damages. And as we mentioned, these are also referred to as liquidated and ascertained damages, and are damages whose amount the parties designate during the formation of a contract for injured party to collect as compensation upon a specific breach. Equitable remedies, specific performance. is a court order requiring the breach party to fulfill their contractual obligations, which we looked at earlier. Injunction, a court ordering the preventing breaching the contract of continuing the breach, which again we looked at earlier. Prohibitory, mandatory type, case of Warner Brothers and Nelson. Rectification, correcting errors in a written contract to reflect the party's intention, the case of Craddock Brothers and Hunt 1923, and rescission, which cancels the contract, restoring the parties to their pre-contractual position, the case of Carr and Universal Finance and Caldwell. Other remedies available, you've got quantum merit definition, which we looked at earlier as well, and repudiation, that's available for the injured party. So the summary table in regards to this, we looked at the element of the different types of damages, so compensatory, consequential damages, nominal damages, liquidated damages, and specific performance, injunction, rectification, rescission, and quantum merit. We looked at this table. The summary table looks at the definition, the example, and the key cases that identify this. So we looked at them, so you could look at that key table in your own time as well. So in conclusion, the remedies available for breach of contract include damages, legal remedies, and equitable remedies such as specific performance, injunctions, and rectification. The type of remedy depends on the nature of the breach and each individual circumstances of the case itself. So it depends, the courts will consider that both parties are dealt with fairly and they're in a position that they have, you know, they've been dealt with fairly and they're in a position if the breach had not occurred. So the courts will take into account individual cases and the merits of individual cases. So we've now finished learning outcome 4, and these are the references we've used for learning outcome 4 that you can look at in your own time. And I'll just give you a summary of what we've done in today's session, which is learning outcome 4. We've looked at understanding how a contract may be breached. We've looked at breach of contract or one or more parties. We've looked at what is breach of contract and how a contract may be breached. We've looked at the types of breach. So you've got actual breach, anticipatory breach with reference to cases. We've looked at breach of terms, so how a condition, warranty, inanimate term, how that could be breached and whether the term is a condition, warranty, or inanimate term. We've looked at remedies for breach, such as compensatory, consequential, nominal, and punitive with reference to cases. We've looked at specific performance, injunction, rescission, quantum merit, and we've looked at elements of the effect of breach on a contract. So the actual breach, anticipatory breach, and repudiatory breach. We've also looked at breach of a contract by one or more parties, which occurs in regards to the breach, party fails to perform their obligation or party performs their obligation defectively. We've looked at anticipatory breach, repudiatory breach. We've also looked at the effect of breach on remaining contractual duties. And we've looked at the role of equitable remedies in contractual breach. So things like rectification, specific performance and injunction. And when is rectification granted, when is specific performance granted with reference to cases, and when is injunction granted and the different types of injunction. So you've got prohibitory and mandatory injunction. We also looked at the requirements for accessing equitable remedies. So, you know, including the clean hands doctrine, or no adequate legal remedy and non-undue harshness and timeliness. We also looked at 4.3, which was types of contract breach, including anticipatory and repudiatory breach, and the effect on contract that it would have. We also looked at the key features of each breach and how it would affect it with reference to cases. We looked at minor breach as well, with reference to cases such as Bittany and Guy, which was quite a popular case in 1876. We also looked at elements of effect on the innocent party obligations and its severity. We then went on to look at the meaning of damages in relation to contracts, compensatory damages, consequential damages, nominal damages, liquidated damages, and punitive damages in more detail. We looked at how damages are calculated in regards to that and the effects of that. We also looked at factors affecting damages, and we looked at remedies available for breach of contract, legal remedies, equitable remedies, and other remedies, and looked at the different types of remedies available with reference to case law. So we've now finished learning outcome 4. The next learning outcome is, the next session is assignment discussion. Some preliminary, if you've got any questions or anything, please email learnerworks@ukvarsity.co.uk. And also, so I've put a link there that you could do some further reading. It's a PDF document. There's ebooks and journals and also resources available on Moodle for you, and all the recordings of all the 4 sessions. And the next session we've got is assignment discussion session, and that will be the next session, and then you will be able to, you will have 2 weeks to submit your assignment. Thank you for attending today's session, and thank you for cooperating. Thank you.